Good morning and welcome to the Court of Appeals. I want to take just a few moments before we get started to go over our procedure. I know I've got experienced practitioners here today, but it always makes me feel better to know that we've talked about the process. First of all, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, the proper way to do that is after you've come to the podium and introduced yourself, but before you begin your argument to request that rebuttal time. You may request up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. We have a lighting system on the podium, and we believe it to be very straightforward. But then again, we see it every day. So, the lighting system works as follows. When you begin your argument, the light turns green. So long as the light's green, you got plenty of time. Once the light turns yellow, you're running out of time. And once the light is red, you are out of time. And we ask that you please respect those time constraints. One very important thing for everyone to understand. We have a very open court system in the state of Tennessee. What that means is that all our oral arguments, unless otherwise designated, are streamed live. So if you're arguing, please think about what you're going to say before you say it, because once you've said it, it's out there and you can't take it back. Our arguments are also can be accessed on our YouTube channel as well. So if you want to go back and look at any of this. Your panel this morning consists of Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
Araceli, Cordova et al. Versus Nashville Ready Mix Eat et al.
Good morning, Your Honor and honors. May it please the court. My name is Dave Rich, and I'm a member of the Nashville-Davidson County Bar, and I have the privilege today of representing the appellant plaintiff, Araceli Cordova, both individually and on behalf of her minor children, as well as the estate of her late husband, Sergio Garcia Lopez. At this time, I respectfully request to reserve 5 minutes for my rebuttal.
All right, sir. You may begin.
The trial court erred in adopting the second special master's findings in total without sufficient support in the record. This appeal presents several critical legal issues, including the eligibility of appellee Rachel Wall, a non-attorney, to recover an attorney's lien, the procedural and substantive errors in the trial court's adoption of the second special master's findings, and finally, the broader implications of allowing a non-attorney to share in legal fees under Tennessee law. These issues are paramount to ensuring the adherence to both statutory distributions and Tennessee rules of professional conduct. Today, I will be presenting 3 primary arguments in support of reversing the trial court's award of $150,000 to Rachel Wall, an individual. Number 1, the closure of the estate of the attorney, Mr. Hodges, extinguished any further lien claim in this matter. Number 2, appellee Rachel Wall, again a non-attorney, is not entitled to an attorney's fee, to share in that attorney's fee, under Rule 5.4 of the Tennessee Rules of Professional Conduct. Additionally, it is not permitted under statute TCA 32-714, which is argued in the briefs. And finally, number 3, the procedural and evidentiary errors of the trial court require reversal. First, the relevant procedural history of the case that goes back, Your Honors, to March of 2013. And so it begins of this matter before the court today, the second iteration of the appeal, is that on August 3rd, 2018, the first special master awarded $133,333 to the estate of Hodges. On May 19, 2020, this Court of Appeals reversed that ruling, remanding the matter for determination of a reasonable fee under the 10 factors of Professional Rule 1.5a. On October 15, 2020, Rachel Wall deliberately and willfully closed the estate of Hodges, of which she was the executrix. On November 12, 2020, Mark Olson, the attorney for Ms. Wall now, and was prior the attorney for the estate of Hodges, entered his first notice of appearance on behalf of Rachel Wall individually, seeking to reopen the estate of Hodges based upon a mistake under Rule 60. On October 19, 2021, nearly a year later, the Dickson County Probate Court denied the reopening request of the estate of Hodges. Subsequently, the estate of Hodges abandoned their attempt to reopen the estate on appeal at this very lectern. On July 17, 2023, the second special master held a hearing. On October 2nd, 2023, the second special master's report was issued, awarding this time Rachel Wall, an individual, even more money than had previously been awarded, that being $150,000. On March 7, 2024, the trial court adopted the special master's findings in total, and on March 27, 2024, this appeal ensued before this court. The first issue is that the closure of the estate of Mr. Hodges extinguishes, as a matter of law, any lien claim to share in an attorney's fee on the Cordova Family's Tort Award. The estate of attorney Gary Hodges was closed by appellee Rachel Wall, who was acting as the executrix. Under Tennessee Code Annotated 32603, an estate is considered closed when all required steps, including the payment of debts and distribution of assets, have been completed. Once the estate of Hodges was closed, it no longer held any standing to pursue claims, including the attorney's lien claim in this action. The closure of the estate extinguished its standing, and appellee Rachel Wall cannot revive this claim by assigning the estate's claim to herself as a non-attorney. One of the key factors that I want you justices to focus on is the incongruent claims that were maintained by the estate and Ms. Wall in her role as the executrix and the individual. First, it was claimed as a mistake. Ms. Wall sought to reopen the estate to resume the lien claim. In Mr. Olson, the attorney's motion to reopen the estate of Hodges, he acknowledged the estate could not pursue an attorney's lien while being closed. He, quote, said, "Counsel would show to the court that the estate is still pursuing a claim for attorney's fees due the estate of Hodges. As a result, the estate should remain open." Then the estate withdrew its appeal of closure, and it was found as a matter of law by the Dickson Probate Court that it wasn't a mistake, and stated that it was by design from the beginning that Ms. Wall was going to assign herself the claim, and did it before the closure of the estate. These two things are not pleading in the alternative. They are incongruent claims that do not make sense and somewhat acknowledge the waiver and the withdrawal and the extinguishing of the estate's claim upon closure. Yes, Your Honor.
Could the estate be reopened now?
I apologize, Your Honor.
Could the estate be reopened now?
No, Your Honor.
You have a definite amount. You didn't have a definite amount before.
Your Honor, I would say no, and the reason why is because the administrator and the executrix had this claim pending. Indeed, the estate was a party to this very case. And so by the estate closing while it's pending, and that's the distinction between the case law and the statute being found at 714, is that when you have an administrator, and that administrator has an active claim, and the claim is ongoing, and then the administrator willfully and deliberately closes the estate, at that point it extinguishes. This case cited by the appellee in support of their case, the Allen versus Critchfield case, is distinguishable easily based on the fact that that was a claim that was never made. It was a claim that was never made under the Federal Employee Act for wrongful death. And when the claim was never made, and then the estate is closed, and then subsequently the federal court granted leave in a 2-page opinion, not even 2-page opinion, allowing the widow with her children and the other descendants to proceed on those claims. Completely different situation. It doesn't apply to the present case. So finally,
So it's your position, if I understand correctly, it's your position then that if money were to suddenly come into the hands of the estate from some unknown source, if there was money out there that no one knew about, that then that would perhaps create an opportunity to reopen the estate. But because this claim was known about at the time the estate was closed, that it is different in that regard.
Correct, and indeed the estate was a party to this case and gave away its claim, closed the estate willfully under a petition that was sworn by Ms. Wall herself. So yes, that distinction makes a huge difference, because it's not a situation where an estate is closed and then suddenly a claim is realized by the descendants of the estate, and then they seek to reopen it under 714 under those limited circumstances. And that's why the language of 714 is so key. It says right in the statute, when all the debts of any deceased person are paid in full and the administrator or executor of the deceased person has resigned or is dead, and there is no person representing the deceased person. That's the first part. Here there were two lawyers representing the estate at all relevant times. And then it says, as administrator, and it uses the conjunction and that's important here, and there are claims due the estate of the decedent that from insolvency or other cause were not collected by the administrator. Here, that is not the case. This was a willful closure while this lien claim was pending. The distinction is obvious and it's open in the statute, and the language of the statute clearly contemplates that we don't want estates just reopening. The finality of closure of estates in 603 is there for a purpose, and 714 would somewhat swallow the rule if every time an estate was closed, you could just simply reopen it. Here, this was a willful closure, which is key. The final two, which I didn't have much to, oh, go ahead, Your Honor.
Do you have any case authority for your position that 714 wouldn't apply to the facts in this case? Because what you had is a claim that was not collected, and that's what 714 talks about. And then it allows the next of kin to pursue that claim. And that's, as I read it, what happened here. And it's not the assignment of the claim, and the trial court didn't rely on this assignment. The trial court relied on the statute that indicates that the next of kin can pursue the claim. And the claim is the estate's claim. It's not the daughter's claim.
Correct.
She may get the benefit of it because she may be the only heir, but it's not her claim.
Yeah, exactly, Your Honor. I would agree with the second part. I must respectfully disagree with the first part, and I see my time is ending, so if I can just have leave to answer the question. The end of your part is correct. There is no estate anymore. The estate is closed, and those matters were settled. They weren't appealed. They were left to rest. So the estate is now closed and no longer a party to the case. So this is only Rachel Wall individually, procedurally before the court. So I agree with you there. The distinction that I would make and the respectful disagreement that I would have with you in your reading of 714 is that when you talk about the pursuit of the claim that's contemplated in 714 is when there's no pursuit. We don't have a claim, we haven't had any pursuit, and now we know of a claim and we need to pursue it. That's what 714 is there for. What happened here is there was a pursuit, there was a claim. We were arguing it. It was before and pending before this court. And then willfully, deliberately, Miss Wall, as the executrix of the estate, swore under oath and filed a petition under the guidance of her counsel to close that estate. And that is why 714 does not apply in this situation. That pursuit ended willfully by the estate. So I agree with the second part. It was the estate. It was just pursued and then willfully concluded and closed.
Can you cite me to a single case that supports your interpretation, 714?
Your Honor, I do believe there was a citation in the record. Let me, if I may, I believe the case that we cited, And I can take a look and maybe address this further on rebuttal, but I believe, Your Honor, it was the Ballard versus Hersky case at 924 Southwest 2nd, 652, and that's a Tennessee Supreme Court case from 1996. And I believe that's cited in, if I recall correctly, the comments of 714, and that's where we cited it. But basically, we rely on the plain language of the statute and how that distinction exists in this case. Thank you, Your Honor.
Thank you.
Good morning.
Good morning.
I'm Mark Olson from the Montgomery County Bar. We seem to have focused primarily on one issue, so I'll address that issue first. The issue of the substitution or continuation of the claim, in my mind, is really probably the least meaningful argument that anyone could advance in this case because it's so clearly resolved by statute. The statute, using the last three numbers, 714, is intended to do exactly what it did, to allow an estate to be closed and not require the estate and the probate matter to be maintained open forever. And respectfully, this issue, counsel tried to intercede in the probate matter. I was not counsel for the probate matter until after some matters had gone on. They had dismissed it. Counsel for the probate estate was actually another lawyer from Clarksville. But we looked at it. The other lawyer closed the estate, although this claim was ongoing. But when we looked at the statutes and we looked at what is provided, closing the estate and allowing the claim to continue on is exactly what the statute 714 is intended to do. This was considered, again, counsel was not a part of and I don't think had standing to participate in the estate matter because they had neither a claim or anything else. We had a claim from the estate. But counsel attempted to bring this matter before the court, Judge Wallace in Cheatham County. He looked at it and he made reference to the statute and he made reference to Pritchard's, which we felt was very definitive in its definition of continuing the claim. In other words, just because a claim goes beyond, it's not intended to end. You assign it to the heir takes it. And to be honest, in looking at the statute, there's not a requirement that there even be an assignment. The claim just continues. But that seems, in my mind, to be the issue that they focus upon, and it's without merit. I am not, Judge Armstrong, I have not been able to find a case that would support what they advance. I have looked, and I do not find that anything would say you are extinguished with regards to an existing claim when you are the sole heir of the estate and the estate is closed. I think that what Judge Wallace did was exactly correct in entering an order that said it continues on. That's what the statute says. I don't think that that technicality was intended. Now, I did want to address a couple of the other issues that are addressed. This litigation's been going on literally for more than a decade now about attorney's fees. This is relatively new. This is a different panel than we've had before. I will tell you, Gary Hodges was an attorney, good attorney in Clarksville, Tennessee, got the case, progressed it to a point where there was significant offer of settlement made. It was a tragic case out of Cheatham County, the death case. He was then discharged, and other counsel took over. Mr. Rich and his firm took over, and they continue on with the case, and they ultimately settled the case. There was an attorney's lien that continued on. Hodges' attorney's lien continues on, and the arguments have been made repeatedly that because Hodges died after the case was settled and the attorney's fee issue had not been fixed, that in some fashion his estate cannot recover under 5.4 of the professional rules. That's just not accurate. It's a totally inaccurate adoption of the rules. We've addressed that, I believe, in the previous Court of Appeals matter, and I really don't understand how that continues to keep coming up. This is not a case where Mr. Hodges' daughter was working on the case and she's not licensed. This is a case where Mr. Hodges' involvement ended, the case was resolved, and then Mr. Hodges died, but the idea of the amount of attorney's fees he received had not yet been settled. So we kind of think that that is groundless also. I don't understand counsel's argument with regards to the second special master hearing, and I'll give the court a little bit of background. We had an initial hearing with regards to the amount of attorney's fees which were to be awarded. And in that case, Mr. Hodges' estate was awarded $133,000. This court looked at it and said, we don't think there's sufficient discussion with regards to Rule 1.5 regarding fees under the professional rules, so the case was remanded. Judge Wallace in Cheatham County appointed a special master to conduct a hearing, and in fact we did that. And we entertained testimony for an entire day, and there was, as a result of that, a transcript prepared. At that hearing, the only parties who provided any testimony was the estate or Rachel Wall. The parties who were opposing the award of attorney's fees did not submit evidence, one. They may have submitted an exhibit questioning my witnesses, but that's all that it would have been. And I'd point out that none of the attorneys who were involved in the case on their side, be it Mr. Rich or other members of his firm, provided testimony. The individual who is the decedent's widow did not provide testimony. The only parties who provided testimony were parties who were actively involved in the case and participated in litigating the case. At the end of that trial, the special master requested a transcript and it was provided. And then he issued a very thorough, I thought, order, 11-page order, that specifically considered every factor under 1.5 of the professional rules. That was filed with the court, and about 3 days later, I filed a motion to affirm that finding. Nothing happened on that for a while, and a few months later, Mr. Rich filed a objection. It was an untimely objection. I only bring this up because this is one of Mr. Rich's arguments. It was an untimely objection, but nevertheless, the court entertained his objections. Judge Wallace conducted a hearing, and he found that the special master's report set forth adequately the factors, described the factors that should be considered, and carefully considered matters under Rule 1.5. As a result, this court is now presented, and I bring this to the court's attention only because it's an interesting question as to the standard of review of that part of this case, with a case that has gone through the special master function and then has been approved by the circuit court. Respectfully, in looking at Mr. Rich's arguments on those issues, it does not appear that they have timely identified any specific issues under which the special master's report could be challenged before this court.
What about the special master's finding that Mr. Hodges obtained a settlement offer of $450,000?
Yes, that was supported by...
That's supported by what?
That's supported by a letter. We will offer you $450,000 in settlement of this case.
Is that contrary to the Court of Appeals ruling in Cordova 1 that said you only look at the $400,000 amount?
I don't think it is, and I'll tell you why. There was not a limitation that was placed upon the special master, in my opinion, by that case, by the Cordova 1. What it says is there's a $400,000 deal. But the distinction here is the court sent that back for testimony. The court sent that back for testimony, and the testimony was entertained, and that included the specific offer letter that was made. And that is a part of the record. I think part of what happened in Cordova 1 that was a problem, in my opinion, was the judge overseeing the case said, go have a special master hearing, but just submit some documents and tell them your position. And that was probably not a good substitute for a full-blown trial where things were presented. So I think that that's an appropriate area for the special master on the second.
Well, I'm reading the opinion, and it says that we affirm the finding of the $400,000 offer
It did, yes.
contemplated by the rules, and they remanded it for the special master of the trial court to consider other factors, not just the amount of the offer.
Oh, I agree.
But the Court of Appeals, in the first case, different panels, said the amount to be considered was $400,000.
And it was. And it was.
Well, no, now we've got a special master saying it's $450,000, which
Well,
is different from what the Court of Appeals said, and Cordova won.
Cordova 1, again, was based upon a situation where no evidence was submitted but for some written documents. Respectfully, Cordova 2 was the reference for specific testimony, and specific testimony was undertaken. Even if you were to assume that $400,000 was the number, the special master still found that $150,000 is the appropriate fee. And the reason I find that interesting is because the special master did not just go by rote and say, you know, the standard is to give a third. That's not what the special master did. The special master came down specifically looking at each of the factors under section 1.5 and came up with an award. So
And is the award 1/3 of $450,000?
it probably was, but again, as I say, I kind of anticipated that the standard was not something that was articulated by the special master. What the special master did was, the special master stated, based upon the factors of 1.5, we find that this is the appropriate award. Respectfully, you know, I think the special master was remanded something and was told, or not special master, but this court remanded something to the circuit court and said, find out what is the appropriate fee under 1.5. And I don't think if I read that Hodges decision correctly, Hodges 1, it did not restrict, it did not enhance. It said, you find out what the appropriate judgment is. So I don't think it said you can't go above 133. I don't think it said you can't go below 133. I think it said you have to find what the appropriate judgment is. And I would respect.
Why is not the number in the original Court of Appeals opinion the law of the case?
Because this court rejected it.
No.
The 400,000.
This court set a specific number.
Okay, I guess that's my point. Even if you accept that $400,000 is it, which is an error, it is an error.
You had the opportunity to file an application, a petition to reconsider.
Sure. Even if you accept that that is an error, what Hodges
Well,
won.
we don't have to accept it's an error because it's in the opinion.
I understand. I understand. Respectfully, it's in the opinion, but it is not the appropriate number, which, you
Well,
know.
it's your position, it's not the appropriate number.
It is my position, it is not the appropriate number, and it is supported by specific law that said the offer was $450,000.
If the trial court had subject matter jurisdiction to consider it after a remand from the Court of Appeals.
Understand. But this would be my question for the court. Was there anything?
We don't answer questions.
I know you don't answer it, but I think this is the question that's presented to the court. I've been here once or twice, but I think that the answer.
That's good.
I think the question that I think is presented to the court is this. Does Hodges 1 limit or curtail the recovery of attorney's fees? It does not. It set forth, we think that $400,000 is the number. Fine, we accept that. But
I
where?
don't think it said we think.
No, I agree. But where does Hodges 1 limit or enhance the actual fees? What Hodges 1 said was, okay, we think this is it, $400,000. We're sending it back. You find out what a reasonable attorney's fees is under 1.5. And that is what the mandate was that was sent to this court. And that is exactly what was done with regards to the special master's opinion. And I did anticipate that 400,000, but that, in my mind, it is kind of an interesting case because what Hodges 1, in my opinion, stands for is we don't do this by rote. You don't get a third because that was the contract. You have to find what is reasonable, what was reasonable under 1.5. That's what the special master did. But what happened is the special master, considering 1.5, said, I think $150,000 is reasonable. And that is where the Hodges decision, I think, is interesting.
Can the special master do that if the contract says 1/3?
The contract didn't say that, is what Hodges 1 said. The contract said 1/3. However, if we're discharged, you have to find a reasonable fee. That's what Hodges 1 said. Because, again, if it had just been a rote thing, we wouldn't be here. Court didn't say it was rote. The court didn't say, okay, it's 1/3, bingo, that's it. The court said you have to find what is the reasonable fee. And that was my reading of Hodges. Of course, my reading's not as important as y'all's.
Well, let me ask you, the contract, if Mr. Hodges had completed the representation, he would receive a fee of 1/3, but because he didn't, you don't look at that 1/3 amount, then you have to look at what is a reasonable fee.
Correct.
Why would the reasonable fee amount ever exceed the contingent fee of 1/3? Because that's what you're suggesting.
It is, and
Because
I
the
think,
Court of Appeals said you look at the $400,000 amount. And now you're saying, looking at it as a reasonable fee, that he can get $150,000, which exceeds 1/3 of $400,000 offered.
well, I think, you know, in litigating these kinds of cases and dealing with attorney's fees, and I've bumped into this a few times, you look at more than just what the contract is when the contract amount, the 1/3, is thrown out. And that's what this court did. This court said, go back and find a reasonable fee. At that point, and I have always felt that this is appropriate, a lot of things get taken into account under 1.5. And one of the things that gets taken into account is, did you preserve this person's right to a cause of action? Did you advance this person's right to a cause of action? Did you benefit this person? Mr. Hodges did all of those things, and then he was discharged. You know, at a point where you've got a $450,000 offer, we think, court has said 400, that's fine. At that point, it's a reasonable fee. And again, I'm just using the language that this court adopted. You have to go back and you have to find a reasonable fee. The court did not say you are limited to the 1/3. The court did not say you can't go below 1/4. The court didn't say anything like that. What this court did is remanded it and said, this fee contract says if Mr. Hodges is discharged, he's entitled to a reasonable fee. So that's kind of it. And it's kind of unusual, and I understand what you're saying with regards to the 1/3, but I'm just following what this court said.
Thank you.
Thank you.
Hear the rebuttal?
Yes, Your Honors, thank you. First and foremost, the $400,000 issue that was discussed was the first of many errors. There isn't any wiggle room or whatever the twisting that was just done there to try to argue that. I cite specifically to the opinion where the Court of Appeals says, this court affirmed the specific finding on remand, quote, that $400,000 offer was the results obtained as contemplated. Then the special master says in his findings, the amount of $450,000 was the result that had been obtained. The two are just completely an opposite. So that's clear error, but there were multiple errors, and I didn't get to address many of them, but principally, putting aside all of this, Number one, Rachel Wall under Rule 5.4 as a non-attorney, because that's how she appears before this court today as an individual. She's not the estate. She's not a representative of the estate. She's not even considered a descendant of the estate. She's just herself, an individual. And so for her to share in this attorney's fee would be an open conflict with Rule 5.4 that prohibits sharing of fees. Now, the other
You have
thing,
a specific case that says that?
yes, Your Honor, we cited throughout our brief multiple cases, and I just left my, I will just, can I stand on my brief since my time is short on rebuttal? We did cite a number of cases in our brief regarding Rule 5.4 and its application. But in addition to that, the special master made a number of errors because, again, what is critical in this case is Mr. Hodges was fired for cause. What's in the record is the affidavit of Araceli Cordova that was filed soon after she fired Mr. Hodges. He signed a contract with Ms. Cordova. Then he hands the case off to Mr. Martin, an attorney in a separate practice not related to him. And then that case sits there for over a year. No answer is filed, no discovery is done, nothing was done. And that was principally why Ms. Cordova terminated them. So the argument that's just been created that isn't evidence, it's not evidence in the record, that Mr. Olson says Mr. Hodges put forward this effort on behalf of the Cordova family, there's no concrete evidence in the record of that. In fact, there's not even a single pleading, letter, or anything that is signed that bears Mr. Hodges' actual signature that was filed in the underlying litigation.
Where was this affidavit filed?
It was filed both into the record in this court. It's been filed in the underlying Dixon County probate proceedings as well.
Was it filed in relation to the determination of the attorney fee by the special master?
It was filed in relation to the determination of the lien when the lien was filed. So Mr. Martin and Mr. Hodges, when they were terminated, like literally about a week, I would say 3-4 days later. In fact, I have the date. It was in July.
The question is, when the attorneys, when the amount of the attorney's fee was determined by the special master, the second special master, was it filed in that case?
Yes. It's been filed multiple times, and I apologize to your honors for having to read it multiple times in the record, but it was associated with different pleadings filed in the case. But the principle, and one other thing I want to point out, Mr. Olson said something that under Rule 1.5, when you move your case forward, when you do a good job on behalf of your client, those are not factors under Rule 1.5a. There's 10 factors. The first factor in the determination of whether a time is reasonable when an attorney's been fired for cause, number one, how much time did they spend? And if I may briefly conclude, your honors, I do have a minute left, sorry. The number one factor is time. They have the burden of proof. Why did we not have to have any witnesses at the second special master hearing? We don't have the burden of proof. We're responding to their lien claim. And what did they provide? They provide Mr. Martin, who already admitted he pursued an unethical lien claim under Rules 1.5c and e. So his claim disappears. He has no entitlement in this case. But he reappears, and he's testifying on behalf of Mr. Hodges. And this is an imperative in the case that this bias exists. It's totally unable. Number one, it's prejudicial to my client because we can't confront Mr. Martin saying, well, Mr. Hodges, in my recollection, did a lot of work. Well, there's no evidence, there's no concrete evidence, and the special master accepted it wholesale. And the final thing that muddies, the water here is that Mr. Hodges was the workers' compensation attorney for the Cordova family. And in that, there's a file. In that, there's letters signed by Mr. Hodges, etc. There's nothing like that in the case. So any claim under the 1.5a first factor of time, it's just absent in this case. Respectfully, your honors, if I may conclude, I just would like to say that we request that this court reverse the trial court's adoption of the second special master's reported award of $150,000 to appellee Rachel Wall because she is a non-attorney, and distribute the full balance of the $450,000 that remains on deposit with the Cheatham County Circuit Court to the Cordova family. We further request that the court tax all costs of the special master specifically, as well as the court costs to Ms. Wall in this case as well.
Let me ask you, the money
Yes,
that's
Your Honor.
on deposit with the clerk's office, will the Cordova family get any part of that?
As a conclusion, no, but Your Honor, the Cordova family has a contractual relationship with our firm and her attorneys. There's multiple attorneys that represent the Cordova family, and the family wants to live up to those contractual obligations. And indeed, the money that is on deposit will go to her lawyers to pay her contractual obligation to satisfy the fee, but in terms of it, it is the Cordova family's tort award. So like all cases, when there's a contingency fee arrangement and the plaintiff's attorneys are inheriting the liability of the case, paying for the costs, all of those things, and prosecuting a case that they don't know will ultimately be successful, to allow that is ultimately considered a part of the award. So to answer your question, yes, it will eventually go to the Cordova family's attorneys, but the court should consider that in the context that it's a part of the Cordova family's award, and the Cordova family had a contractual obligation, which it wants to honor to its attorneys for doing a good job in the case and getting a much more sizable award than was ever
You've answered
offered.
the question.
Thank you, Your Honor. I apologize.
Thank you, counsel. We will take this matter under advisement. We will endeavor to get you an opinion as quickly as possible. You may be excused.